Okay, welcome everyone. We're so happy to have Jim Cunningham back. He's been doing a series of these for us, a lot within the arena of law practice management. He's partner and CEO of Cunningham Legal, and he has decades of experience, particularly in trust and estate planning. And I'm going to give it over to Jim. Thank you all again.
Well, thanks for having me and thanks for watching. We're going to go through these materials a bit quickly. For those of you who are corporate transactional or business, have business background, some of this will be familiar. If you are have no background like that, this is going to be news to you. And so we're going to have some new, a few new terms that might get thrown in there you might not be familiar with. But this is something, if you kind of don't get it as we go through it, you can certainly hit the rewind button or slow it down. But what we're talking about here is building a sellable law firm. And a lot of people didn't think this was even a thing. But Ed Pohl, who started this whole process, I think, years and years ago, he had LawBiz. We ended up acquiring the LawBiz property from Ed Pohl. He was kind of the pioneer in this, and it was a real eye-opener for people that you can actually build what we call enterprise value. So value, but we're going to talk about that. So most practitioners, most lawyers who are thinking about quitting, some people are lifers, and if that's you, you're just going to keep doing it till you die. I talked to my dad. He's a retired lawyer. I talked to him a couple of weeks ago. He says, I just thought I was going to keep working till I died, but he did end up retiring. But I think if you want to actually sell your firm or even transfer the firm for no consideration, and we'll talk about those two kind of paths, you have to really start building a firm that somebody wants to take over. So whether a buyer's going to purchase it or if you're just passing that firm to somebody else, that somebody's going to want to take this. Right? So it's something that would be desirable. So we're going to talk about the buyer's perspective. In our firm, we have acquired over 30 practices in the last 20 years. And you're going to hear what buyers really want because that's us. We've been on the buy side on 30 plus deals. And we probably looked at over 100 estate planning practices in our particular field. So you're going to leave with some actionable strategies at the end of our time here together and to create value and avoid red flags. So I'm a partner at Cunningham Legal. I have over 30 years experience. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust and probate law, a real estate broker, securities and insurance licensed, and a pilot single engine land instrument rated. Although I'm not current, I was based out of Camarillo. This is a disclaimer. This is very important. I'm a lawyer. I'm talking words are coming out of my mouth. This is not legal advice. When I say you, there is no attorney-client relationship. Now, this is probably going to be attorneys watching this, but it might be the spouse of a lawyer. So it's very important to understand that if that's you, there's no attorney-client relationship. So why are we even talking about this? Why this matters? I think it makes sense to ask yourself, do you own a job or do you own a business? Do you own a job or do you own a business? Most law firms, I will say, this is really a hard truth. Most law firms need work to be sellable. Most law firms are not, frankly, in a sellable condition. They are often profitable jobs, not transferable businesses. So we often say, oh, that practice, somebody's buying a job, right? And we'll talk about that. Revenue itself does not create value in the eyes of the buyer. Important to understand. If it can't be run without the owner, then there's really no business to acquire. You're essentially acquiring a client list. 91% of California law practices have fewer than 3 lawyers. And this is from a publicly available World Metrics, right? So the huge bulk of law firms in California or legal organizations are 3 or less lawyers. And sometimes it's 2 partners retiring at the same time, right? Or maybe the 2 partners retire and the associate says, look, I just want a job. I don't want to run a business. I don't want to have to make payroll, pay rent, have that sort of liability. It can be, if it's not an enterprise, a business, it can be the purchase, as I mentioned, of a client relationship or a client list. And that's usually reflective in the price and that you're going to typically get a lower multiple. And we'll talk about what a multiple is. The demographic clock is ticking. Most California firms are owned by people 55 or over. And this is just a pure demographic trend. I happen to be a Gen X. I'm 56. I'm going to be 57 pretty soon. So we're kind of, the Gen X is kind of the glue that's keeping together the boomers and the millennials. But a lot of boomers are exiting and there really isn't a clear path for them to exit. And we were talking before we started, if this is you, if you're a solo and it's your practice and something happens to you and you're married or you have a partner, your surviving spouse or partner is going to have to deal with your practice probably for the rest of their life. So unless you do something to transfer that practice, it's very important to understand is these things just kind of keep dribbling on years and years and years. I would say internal succession tends to be rare. Many times the buyer does not have the means to buy, and we'll talk briefly about that. Younger lawyers, in my experience, younger lawyers often prefer employment over ownership risk. I'm a latchkey kid. When I got home from school, there was no one there. There was no internet. I just had to figure stuff out for myself. That is not the crop of kids coming up now in kids. I mean, people in their 20s and 30s and even 40s. So there is a little bit of cultural difference that is tied to age. Private equity, PE, private equity is increasingly interested in platform firms with infrastructure. What is that? That is firms of $10 million or more in revenue. And I've been talking to private equity this year and last year, a couple of different firms, and kind of gauging what's really going on. What are you looking at? We're seeing this typically in the personal injury space and estate planning space. That's kind of where we're seeing the activity. Firms without a transition plan are really running down their own equity clock. The standard deviation curve that you might have learned in school, it's the standard deviation curve. Your clients are likely 10 years older to 10 years younger within that standard deviation curve. The older you are for estate planning, it gets better, but then it almost you get too old. Okay, so if you're 85, a lot of your clients have already passed away, or that trust administration work is done in the estate planning context. So think about your age, and it's not a negative, it just is. I mean, it's just a reality. And if you're 60 and over without a plan, as we say, you're consuming enterprise value every year. It's sort of getting worth less and less every year. Time is either compounding value or eroding it. There are 4 ways. I did not come up with these. These are the nicknames the author Patrick Ungashik gave. There are 4 ways to transfer a practice. You can pass it, you can do an inside deal, you can do an outside deal, or you can just squeeze the life out of it and shut it down. That's the passer, the innie, the outie, and the squeezer. And we do have, I just started using Manus, MANUS, which is a Meta product this week. These are photos. These are AI photos. This is crazy. AI is a very powerful tool, but here's a passer, and here's an example of maybe a father passing the practice to his daughter. This is where you transfer your practice for no consideration, right? No money, typically to a family member. Now, this might be you. You might have a family member, and you say, "This is great. My daughter, she became a lawyer, and now I'm going to transfer my practice to her. That's great." That's what we call a passer. If you want your daughter to pay for it, that looks more like an innie transaction. So what is an innie transaction? That is a transaction to associates. And here we have an image of a woman transferring her practice to 3 associates. These may be, in your practice area, these could be the best or potentially the only potential purchasers. And this really depends on what you're doing in your practice. This oftentimes is implemented gradually over time, where ownership and control is passed in stages. The gradual transition does have the benefit of reassuring clients and lenders, if you have a banking relationship where you have debt, and also the employees of an orderly and successful exit for the exiting lawyer. The problem is associates, assuming they want to be owners, right? Because sometimes they just want to stay W-2. They often lack the cash to buy the practice. So it's kind of like, well, it's an earn out, and we'll talk about what that is. The outie is a sale to a third party. And here we have, again, an AI image, and that is supposed to be the San Fernando Valley, and it kind of looks like it. But here's an example of somebody passing their practice to purchasers. Now, this would be us. So our firm, Cunningham Legal, we have acquired practices through acquisition, so purchase or integration through a counsel relationship, which we'll talk. But really, the seller here should be thinking about readying the business for sale. Should the seller grow the practice? What do I mean by growth? Typically, I'm meaning profitability, not necessarily top-line revenue, or not. Maybe you've just reached this point. Maybe this person who's selling in the picture here is becoming a judge. And you get that call on Wednesday. They say you need to unload your practice by Friday. So that happened with a judge who's currently on the bench in Ventura County in our firm, and we made a quick deal. So that's another context, right, where it's not necessarily there's something wrong with you or retirement. It just maybe you're taking a different position where you cannot keep your ownership interest in the practice. I would say buyers, when it is more than a client list from the buyer perspective, and we'll talk about this a little bit more, typically we're going to be looking at the staff. We may take the staff, we might not. It depends. There's an interview process. Do you keep the name or not? We have we haven't done that traditionally, right? But other people might take your name, right? So if you have a really good reputation, they might want to rebrand and take your name, and then the processes. So we'll talk about documentation of processes. But do you as a seller want to keep your legacy? That may be an ego thing. That's just something you're going to have to figure out. And then we have the squeezer. Here's this poor guy who is squeezing every dollar from his practice until he closes the doors. And these are typically profitable practices with cash flow. Maybe there is no buyer out there, right? Maybe the competitors have a low barrier to entry. We see this sometimes with criminal practices where it's heavily dependent on the individual contribution of that lawyer. There may be no clear path to pass to an associate because there's really, what is there to buy? I mean, there certainly is a reputation, and I'm not throwing shade on criminal defense lawyers. I'm just saying this is when you contrast that with maybe personal injury or estate planning, that typically has more transferable intellectual property. So I would say the smaller, the more disorganized, and the less tech forward the practice. And if I just described you, you're going to want to work on that. So the smaller, the more disorganized, and the less tech forward the practice, the greater the potential is for a squeezer. This poor guy or not. And the reason I say or not is my dad is a retired personal injury lawyer, and he chose to wind his practice down. And in the last 3 years of practice, he made more money than he ever did. That's because he stopped taking new clients, and and kind of wound down his staff, and he kept getting fees. So those became some of the most profitable years for him. And if you're a personal injury practice, that might be as well. So how do firms change hands IRL? So if you're under 50, you might know what this means. This means in real life. This is an internet acronym. So how do firms change hands in the real world? Well, it can be a sale. We're just talking basic structure and what happens to the lawyer. So this could be a client list or book of business. So imagine a solo attorney retires, maybe a partner wants out, and it's a revenue share over time. And we'll talk about what those amounts are and what we see a typical time period. You might have a consulting agreement, you might not. Sometimes there's an of-counsel relationship, and that is maybe a solo practitioner, and we see this in the estate planning context. They merge their practice into a larger firm, and they stay for maybe 2 years, and it's either a 10 and 50 or a 20 and 40. 10% origination, 50% if you originate and work it. Sometimes it's 20% origination and 40% if you originate and work it. So, $100,000 comes in fees, and if you originate that work and you do all the work in a given year, you keep $50,000. If you choose not to do any of that work, you get 10, and the same as on the 40-20, that 100,000 you would be earning 40,000 on that 100, or 20 if you just chose not to work it. So that's what we've seen a lot. I would say certainly in the Bay Area in California, not so much. I don't have as much experience with this in Los Angeles for, I think, market reasons. But in the Bay Area in California, if your book is not $1 million, you're probably not going to get a lot of interest from firms. So there's kind of this $1 million threshold. Of counsel, that's, again, we talked about that. That's where you come in for a period of time. And then senior counsel. By the way, of counsel, what does it mean? It means anything you want it to mean ethically, and we've researched this backwards and forwards. Senior counsel is a little bit different. That's maybe where somebody buys out the book of business. You write a check to senior counsel, but this person stays on, right? And they may stay on indefinitely. And they're bringing their book of business in. Maybe you're paying for the book of business, maybe you're not, but then they do become part of the firm and working with staff and being more almost like a partner. And the reason we call them senior counsel instead of partner is many firms have a cash balance pension plan. That means your contributions are tied to the age of each employee. So if they come in as W-2 versus 1099, the W-2, their pension contribution could exceed their comp. So, and I don't want to get in the weeds on that, but that is why they might come in not as a W-2, but as senior counsel on a 1099 basis. So types of law firm acquisitions, you can have an equity partner buy-in. That's a capital contribution, maybe bringing revenue. That's a way to effectively sell your practice, but really it's a merger or a full entity acquisition. And that's, again, where you're buying the practice. So these are some examples: acquiring a client list and keeping the seller as of counsel, maybe nominally of counsel for a period of time. And again, you can read this slide, and they're just, it's all over the map on what it is, and it really is very case specific to the facts. Internal succession, broadly speaking, I think can produce lower valuation multiples, but preserves the culture and client continuity. You need to decide as the seller how important is money to you. I mean, money is money. It's important to everyone, but how important is it to you? And maybe this ties into legacy, and that's really a personal decision. The payment terms, oftentimes people are not going out and getting like an SBA loan and writing you a check. Although we do see that, I don't see it that often, but typically it's an earn out over a period of time. And external sale may generate a higher theoretical valuation. You may have a strategic buyer, somebody maybe from the San Francisco Bay Area who says, we want a Los Angeles presence, and they're willing to pay a premium because maybe they already have clients there and they're doing it for other reasons, just for the practice itself. So typically those are going to be strategic buyers. Cultural integration can be tough. Is the way you run your practice and you're exiting, is that the way the buyer's going to run? And that's something we pay attention to quite a bit. Your clients, you as the practitioner, like attracts like. If you're kind of a jerk, you're probably going to have jerk clients. If you're a nice person, you're probably going to have nice clients. That's what we've seen. So we really pay attention to, is this person who's wanting to exit their practice, what are they like? Because it tends to be their clients tend to be like that. In our firm, we have a no jerk policy. And the reason we have a no jerk policy is because I don't want a jerk because jerks hang out with jerks. I don't want a jerk to befriend their jerk friends, and all we have are jerk clients. So that's just what we've chosen to do in our firm. External sales, I think, are more complex deal structures typically, and the papering of the deal increases the transaction cost and the time. But these require intentional preparation years in advance. Let's move to the buyer psychology and due diligence. This is the buyer's mindset. This requires an element of empathy, not in an emotional sense, but not thinking yourself as a seller, but what you want to do is look at your practice as if you were a buyer. Okay, this is where deals live and die, right? Valuation is theoretical. Your letter of intent, maybe a memorandum of understanding, however you structure that initial phase. You say, all right, we'll pay you $1 million for your practice. And then the due diligence starts. And then what happens in the private equity space is they're looking under every rock and leaf to get that purchase price down. And so that's kind of what the due diligence, really it's a risk assessment on the buyer. This is where optimism meets documentation. Professional buyers, people who know what they're doing, assume absolutely nothing and verify everything. That's how we run our practice. The less due diligence, the less money you're going to get for your practice, quite frankly. I mean, I think that's kind of a truism. And most price reductions happen at the due diligence phase. Most buyers are going to want to see 3 to 5 years of financial statements, and we're going to talk about what you can do to clean those up. They're looking at tax returns, internal P&L reports. If you're coming in on a stub year, maybe you've got, if you're looking at a practice for in February, they haven't even filed their income tax return for the prior year, you're going to be looking at their P&L pretty closely. You're going to look at AR receivable aging. So older receivables tend to indicate problems, right? So if you have a lot of over 120 or a big 90-day receivable, I would say that negatively affects value. So it should look like, it should look like the backside of a standard deviation curve, not the front side, okay? The buyer's going to look at revenue trends and profit consistency over time. There's something called a 12-month moving average, where you take your average. So in January, you take your prior 12 months and you average the monthly revenue. And in February, you do it for the February to January period. And then March, you do it for the whatever that prior 12-month period is. And you average that out and you're looking at trends. Is this practice growing? Is it shrinking? Are margins growing? Margins is what's left over after, you get your money in and you pay your expenses. What's your percentage margin? 70% of small business deals experience price adjustments after the financial diligence. So you're probably a small business. I would expect somebody says, yes, I will pay you $1 million or whatever the number is. I would expect some type of price adjustment downward. In professional services, inconsistent earnings can reduce valuation multiples by 20 to 40%. And we'll have some numbers on multiples here in a little bit. In our firm, we want to know how, your operations, having your Are your processes documented? Are they dependent on your memory? How does a caller become a client step by step? So estate planning, we tend to have a higher number of clients than maybe a civil litigation firm. If you're handling corporate litigation and your typical fee for representations maybe 500,000, you may only have a couple new clients a year, so maybe it's less of an issue. If you're doing estate planning and your average estate plan is 5 or 10,000, whatever it is, you're going to have a lot more clients, right? So we're going to want to know how does somebody who's has an expression of interest, how do they ultimately become a client? What systems track case deadlines and performance? If you are in a practice area that has, if you blow a statute, it's big time malpractice. Any buyer is going to want to know that. So can the team operate without the founder in the room? I think could be like an all day topic, because this gets to ego, and lawyers have really big egos. And if you're a lawyer watching this, I'm sorry, you probably have a big ego, right? It's just that's just the way it is. But to make yourself replaceable can be very humiliating, I will tell you. And I try and make me replaceable, and I have struggled with that. I will just tell you straight up. I've really struggled with it. Like, okay, other people might do a better job than I do, right? Risk assessment. Buyers are asking one question: Can I be stuck with liability? Am I wasting my money? Is this just a waste of money? Am I going to get sued for malpractice if I take on this practice? Bar complaints, disciplinary history get a lot of attention. If somebody has a bad track record, it's a pass for us, because we just don't want the headache. Whether we're ultimately responsible for a prior attorney's negligence, and in the estate planning case, if someone did an estate plan 20 years ago and we take custody of that file, I don't think we have liability, but we just don't want to deal with it. Okay. And we want to make sure that attorneys are doing quality work, and not all attorneys do quality work. So it's very important. And this is part of due diligence. What is the quality of the work? Trust accountings have to be clean. And we see this, I think probably the number one thing that people get disbarred for is mishandling client money. They have to be clean, and it can't be fudged. And if that's you need to have that straightened out. Employment practices and internal risks can shrink value fast. If you acquire the assets of an S corp in California, most law firms are an S corporation. You are responsible, or either sole proprietor or S corporation. You're responsible for labor law violations going back 4 years as the buyer. So that came out a few years ago, and that really makes us pay. That kind of increases the due diligence, and we're looking at holdbacks and a whole variety of things. American Bar Association says 80% of all attorneys will face a malpractice lawsuit at least once in their career. Estate planning is considered high risk due to liability to non-clients. Even non-clients can sue. And I think in California, I think the average attorney is sued 3 times. So what buyers fear: revenue evaporates right after a public announcement of sale. So, hey, they're retiring and they're out of here. Key staff members resign, right? You need these people. Seller checks out emotionally and stops supporting the transition process. Hidden trust accounting irregularities pop up. Referral sources provide loyal to the individual, not the institution. So if it's heavily dependent on you, and those referral relationships evaporate. And again, if you're 70 and your referral relationships are also 70, those people are retiring too. Maybe they're working. I don't know. Maybe 70. I would probably say a higher number 10 years from now. I'll probably be like 80 when I'm 60, in my late 60s. Unresolved malpractice exposure, operational fragility replaces expected stability. So things kind of go. For all these reasons, by the way, firms often trade at steep discounts. I do want to cover valuation logic, because a lot of people say, Jim, how much can I expect for my practice? And we're going to talk about this. Valuation, I'm sorry to say, and my wife likes to say this. She goes, Jim, you've been working hard for 30 years. Therefore, blah, blah, blah. None of that matters. Doesn't matter. Doesn't matter if you've been working hard for 10 years, 20 years, 30 years, 40 years, or 50 years. It is not based on how hard you have worked. It is not based on what you think it's worth. Valuation is based on economic reality. So what we're talking about here are normalized earnings driving the baseline value. Buyers are going to look at your financials to determine your true operating profit. If you run your car through your business, if you run all your meals and expenses through your business, if you run your travel through your business, this is very common for people to do. These are personal expenses, and these have to be stripped out, right? One-time spikes in revenue are discounted to avoid for overpaying. So if you had like a really big, settlement come in, maybe you're working a contingency, or you had a big collection on something, maybe a really big probate, that's typically going to be stripped out. Clean financial reporting reduces the uncertainty for the buyer, and the clearer your numbers, the stronger your valuation foundation. What are buyers buying? Buyers are paying for repeatable income, not your best year ever, right? This isn't like retiring from some pension calculation, right? This is a real buyer in the real world. Recurring revenue increases predictability. If the revenue has been growing year over year with healthy margins, that is better than declining revenue. So if you say, gee, my practice was twice the size 10 years ago and it just keeps shrinking and I need to find a buyer, I think that's going to negatively impact valuation versus it increasing over time. But again, when everything's going good and your margins are healthy and your revenue's growing, it's like, well, why should I retire? I could be a lawyer until I die. This is the paradox, right? So that's the time when you should be really, if you want maximum enterprise value, that's really when you should be looking at selling. Stable intake patterns lower future risk assumptions, meaning how are people coming to you? How are you generating demand? And the predictability increases the margin. Healthy margins show pricing power and operational control. These are two different things. So what I'm talking about here is your ability to get paid for what you're doing, right? To be appropriately paid, not excessive discounts. By the way, if you're just like tip, don't discount. We don't discount in our firm. We just don't. You're just giving away the store on that one because frankly the margins are too thin in law. If it's more than just a solo practitioner or something, but if you've got 15, 20 employees, you really can't afford to discount. Operational control. This is very, very important to be running your business, running your law practice like a business. These two things show up in a healthy margin. Strong margins protect against market shifts, right? If something happens in the marketplace, you're in a much stronger position, and staffing changes, and this is more comfortable for the buyer. Okay. Founder dependency increases transition risk. If everything is reliant on you, that is not a good thing. All right. And again, this is where the ego comes in. So let me get through. Oh, this is another one. Institutional brand strength improves client retention after sale. What is a strong brand? I think we know what that means. It's kind of hard to have a strong brand when you're a smaller firm. I get that. But you really want to have this client loyalty be transferable through the brand itself. Now, a lot of lawyers name their firm after themselves. If I could wind the clock back, I would not name the firm after myself, because if it's named after you and you leave, I don't think that's as good as if you name your firm something else, right? And that's kind of more common in estate planning practices to name your firm something else. Compliance discipline helps hidden liability exposure. What is compliance discipline? This is making sure that you do everything properly, right? That you're complying with California labor law, that you've made your pension contributions that you have to make, that your trust account is structured properly, that you've had full disclosure on your errors and omissions applications, on your prior errors and omissions applications. This is all the stuff like doing all the things you need to do to run a business. So let's talk about SDE and EBITDA, seller's discretionary earnings and EBITDA. This is a reframing of your ego to move from indispensable to replaceable. And if you say, Jim, I think you're crazy. This firm can't run without me. I'm the smartest person in the world. I'm a lawyer. I'm the smartest person in the room. No one can do this as good as me. That may be fine, and that may be true. I think that's going to negatively impact the value of your law practice. Just objectively, right? Because if you're not there, if you're spending most of your time on your fishing boat in Cabo or skiing in Tahoe or whatever it is you do, that's actually way better, right? Because now you're kind of like a shareholder, you're an owner. If you have management in place, that is far superior for many, many buyers. Okay, what is seller's discretionary earnings? Seller's discretionary earnings is all the benefit you get from the firm. This includes, we have an example here. If you have $1 million in revenue, you and 3 employees, and you take home $500,000 a year, all right? You're putting half in your pocket. That is your seller's discretionary earnings, $500,000. So that's kind of what we're talking about here. I would say the low end is 1 to 1.75 times seller's discretionary earnings. This is where we see owner-dependent revenue, no associate attorneys. We see this a lot with solos. You might have a paralegal and a couple of staff people. I do want to mention one thing. We're recording this in 2026, and so if you're watching this in 2032, the numbers may be wrong. But right now in 2026, if you're running a law firm and your full-time equivalent employees are not generating at least $250,000 a year in revenue, you're going to have problems from a business standpoint. So what I mean by that is if you're at $130,000 in revenue per full-time employee, you're not making enough money to pay quality people, pay all the associated expenses, and generate a profit. So I want you to think about what was your full-time equivalent, meaning if somebody works 4 days a week, it's a 0.8, but you add all these up. And if your people, because you guys are in San Fernando Valley, right? I'm pretty familiar with this market, the labor market. If you're not paying people at least $250,000 a year, I think you're going to have problems that oftentimes are cured by getting your revenue up to $250,000 per person a year. So that's just a little something I came across last year, and it was very enlightening. So on the low end, weak intake process, maybe no intake process. Maybe it's just, the phone rings and we book an appointment and it's all in your head. Revenue fluctuates year to year. We see that a lot with solos. Well, I had a good year last year, but the prior years, I went on vacation and this or that. High AR, high accounts receivable. I can't seem to collect, or I work and I get stuck in this case. I'm stuck in this litigation case and I can't get paid. I mean, what buyer wants that? Few recurring relationships. Right? So if it's, and again, the nature of the practice, if you have clients coming back year over year over year, that's better than, if you're consumer bankruptcy and it's kind of ad hoc, those people can't come back. I guess they come back after 7 years. I don't know. I don't do bankruptcy. Criminal, there may be more recurring business. I don't know, but it just depends on the practice area. If the referral sources are tied to the founder, that is problematic. If you say, I've got this great referral network, that's great, but that's going to have to transfer to the buyer, and that is more risk for the buyer. The middle range we see as 2 to 2.5x. This is if you have clean financials, stable margins, predictable intake, some documented systems, not all, staff continuity, they're going to stick around, and the seller stays for the transition. Now, that can be a good or a bad thing, but I'm assuming that the seller stays for the transition and it's a good thing. That can be kind of rough. But this is still founder influenced, so not pure chaos. The founder still is heavily involved, but I think disciplined solos can land in this area, in this sort of 2 to 2.5x on SDE. So the high end is, I say it's rare for solos, but it can happen. This is strong recurring revenue, institutional brand, not personally driven. This is, do you name the firm after yourself or not? Documented procedures, everything is documented. Low revenue concentration. What does that mean? That means like no client it generates more than 10% of revenue or 5% of revenue. So you don't want to have one client generating 60% of revenue, because that's a risk for the buyer. If you lose that client, it's a problem. High referral retention, predictable cash flow, seller committed to structure in a multi-year transition, and strong compliance discipline. This is following all the rules. Trust accounting, engagement letters, conflict checks are systematic. That's a big one. If you don't have a systematic conflict check system, a buyer is going to have a problem with that, right? Documented case procedures, employment law compliance, malpractice risk management, and clean financial integrity, okay? When the buyer feels confident, revenue can survive the handoff. Confidence increases multiples. Okay, there is also something called EBITDA. Now, if you are not a business person, you may have no idea what I'm talking about. EBITDA is earnings before interest, taxes, depreciation, and amortization. EBITDA is your revenue, your gross revenue, minus all of your operating expenses, minus fair compensation for a replacement attorney. This is where EBITDA is different than seller's discretionary earnings. Typically, seller's discretionary earnings are higher than EBITDA. So, what's going on here? If the owner must be replaced, if you're working in the firm, that cost must be deducted. So I would say for most small firms under 5 million in revenue, what we're seeing, this is the private equity space. They're seeing a 3 to 6 adjusted EBITDA. That's what I'm seeing them paying. The bigger it is, the better it is, the 6 times EBITDA. And I'm going to have an example of the difference between on how EBITDA works here in a couple of slides. Low is 3 to 4x EBITDA, mid is 4 to 5. High is 5 to 6. That's where your private equity is coming in. We see private equity coming in if you have $10 million in revenue. You're probably going to want to have 20% of your growth and 20% operating margin. So operating margin meaning, again, what you pay minus all of your expenses, including your own salary, right? If you are your fair market compensation, if you're the selling attorney. So the low range is investable, but not scalable, meaning it's going to be hard to grow if somebody just buys your practice. Revenue is still founder heavy. Leadership bench is thin. Margins are decent, but not exceptional. It's very hard to scale something like this because you're not really buying a business. You're kind of buying a client list that you're going to have to do a lot of work to build your leadership bench and to get those margins up and to even know that those margins are going to be higher because you just don't know. If somebody's already done that hard work of getting the leadership bench, meaning the associate attorneys, the managing attorneys, and a proven track record of margin, that is going to result in a higher EBITDA. But what we're talking about here is something closer to somebody is not as put together as they might otherwise or could be. Some operational documentation exists, yet there is significant transactional transition risk for the buyer. If the buyer writes a check or gets a loan or pays, they're not necessarily as confident as some of the mid or higher. So a buyer sees a functioning firm, but a fragile functioning firm. Again, confidence increases multiples, strong management depth, institutionalized intake systems. How do clients come to us? You have a written documentation. You've got people to onboard clients. Stable associate production. What am I talking about? You have the ability to bring on attorneys, train them, retain them, and make a profit on them. Okay, so this is where you're leveraging your value as the skilled lawyer to teach other people to do so that you can make the spread on the value of their labor. Clean compliance record, of course, diversified referral base. This is really important. If you're reliant on 2 or 3 referral sources for all of your business, that's a risk. Predictable margin performance, and buyers see durability, and durability increases confidence. Confidence increases margin. Private equity really pays attention to, and they pay. So we're seeing 4 to 5 to 6x. That's the conversations I've had in the last 12 months or so. This is where you have multiple producing attorneys. So these are multiple attorneys meeting with clients, maybe partner level clients, whether they're partner or not, but they're able to. And what I mean by a partner is someone's able to take on a matter, work it from beginning to end without any supervision or oversight. So this is somebody who's able to be an independent operator, if you will. Low owner dependency. It's better, and I will tell you, I met with a private equity guy and he was in my office and we met for a couple hours. And he said, he was a recent grad from, I think, some like University of Pennsylvania, something like that. And he said, after about an hour and a half, he goes, I noticed your phone hasn't rung. You're not getting texts. You're not getting alerts or emails. He goes, the people who have the money told me that when I sit with a potential seller, pay attention to their interruptions, because if they're getting interrupted all the time, that is not good. Okay. So you just want to, if you're meeting with private equity, just like mute all your devices and tell people not to call you, I guess. I don't know. So multiple producing attorneys, low owner dependency, repeatable systems, strong EBITDA margins, typically 25% or higher. There's a 40 rule, 20% growth, and 40 meaning your growth plus your margin. It's very hard to grow a firm by 20% a year. I will say maybe 10, 15, 10 is doable. You've got a combination of things where you can get movement there, but it really is best if the sum of your margin plus your growth is 40% or above. Some PE firms are looking for 50% above. Now, you may be asking yourself, how can private equity buy a law firm? Well, there's a legal services organization where the law firm contracts with the legal services organization in perpetuity to provide services to the law firm. So it's no different than a group of physicians that contract with a hospital. It's the same model. And this is something that really is getting steam, and especially in the personal injury. By the way, if you're a personal injury practitioner, private equity, they're looking for PI firms. Okay, recurring revenue elements, brand equity beyond personality, sophisticated financial reporting. That's very important. You should know what do I mean by sophisticated financial reporting? At a baseline, most of us are cash basis. Most law firms are cash basis. You should consider running an accrual basis. What is an accrual basis? Hey, we had a great January. Well, what's your February going to look like? Or what's your March going to look like? Well, and we're recording this at the end of a month. We kind of know what our next month is going to look like based upon our billable time from the prior month. So that's what I'm talking about, running accrual basis. So this is something you'd want to talk with your CPA or CFO or controller about how to do that reporting, because that's something very important. You want to know what the next couple of months is going to look like, because you can make changes now to really alter the outcome. You're getting closer to a platform than a solo practice here. Now, here's how EBITDA multiples compress values for solos. If most of the firm revenue depends on the owner's production, the replacement cost is huge. Shrinks EBITDA, which shrinks enterprise value. And remember, these are multiples of EBITDA. These are 3 to 6x multiples. So for every $100,000 you cut in expenses, or for every $100,000 revenue increase you have through a more disciplined approach, $100,000 in profit you have in a more disciplined approach to your practice, that's $300,000 to $600,000 more in enterprise value. So these numbers become much bigger. Okay. This is why reducing owner dependency increases valuation under both sellers' discretionary earnings and EBITDA models. But under EBITDA, the penalty is more explicit. The penalty is magnified because SDE multiples are lower. If you really want to build your firm to sell it at a higher multiple, you got to be doing the stuff that we talked about. Okay. Seller's discretionary earnings answers the question, what can I personally earn if I buy this job? So if you're a seller and your buyer's coming in and they want literally to buy a job, that's kind of when we look at seller's discretionary earnings. EBITDA answers, what does this business generate if I hire professionals to run it? And you can see this private equity. They're going to hire lawyers. They're going to get lawyers coming in that contract with their legal services organization. And that's how they're going to create enterprise value. The ego loves being needed. The market rewards being replaceable. So again, like kind of one nugget from this is set your ego aside. It's hard. And believe me, it's hard. Buyers who use EBITDA multiples think like investors. Investors care about risk-adjusted return. Investors care about capital efficiency. They care about scalability. They want to grow it, want to turn. Private equity might hold it for a period of years, 3, 4, 5 years, and then turn it to another private equity firm. They want margin protection. You want, as Warren Buffett says, you want to build a moat around your business, and downside containment. If things go wrong, how can you mitigate the risk? If you want to higher EBITDA multiples, you must build a firm that looks like infrastructure, not just your personality, takes intentional design, can take 3 to 5 years of disciplined preparation. The result is, of course, enterprise value. Deal structure reality. Sellers focus on valuation multiples and the highest dollar amount, while buyers focus on structure and minimizing risk. Price is one term. Price is typically the most important term for a seller. Price is not the most important term typically for a buyer. So there's a bit of a disconnect. Purchase price is rarely the amount wired at closing. Upfront, it's going to be a fraction, and the earnout, meaning it's paid out over time depending on the performance of what the buyer's buying, is way more common in professional practices. We see revenue shares of 2 to 5 years, aligning incentives and reducing buyer risk. I've seen some people pay a third of revenue for 2 to 5 years. I think that's too much. You need to look at the margins and a lot of other firms are doing 20% for a term of years. But the reason is, if your operating margin is 20% and you're paying a third, you got to come up with the cash, meaning for every dollar that comes in, you're putting 20 cents in your pocket, but you have to turn around and pay 33 cents. You really need to pay attention to what your own margin is and what that looks like with the firm that you're integrating from the buy side. Sellers can stay engaged as of counsel, maybe senior counsel, and stabilize the transition or not. Holdbacks are very common for undisclosed liabilities and malpractice risks. So holdback or clawback, yes, we'll pay you, but if these bad things happen, then then you're going to get less. Okay, let's look at a couple of earnouts. This is a basic deal structure. What do I mean by earnout? Sam, the solo practitioner, has $1 million in revenue. He's got 1 administrative assistant and 2 paralegals, and Sam. So 4 people, $250,000 in revenue. Sam is disorganized and lacks proper systems. Is this how most firms are? Yes. I think this is how most firms, most solos operate. Sam sells to Billy the buyer, and Sam sails off to the sunset. So he's not staying on of counsel. Buyer agrees to pay an amount not to exceed $500,000, right? Which is 1x in our hypothetical here. It's a 1x of seller's discretionary earnings, or at a rate of 20% a year, collected over a period not to exceed 3 years. So year 1, the revenue bumps to $1.25 million. Why does the revenue increase? What we found is many times Sam is not marketing to his client base. So when you send out the letter, which we're going to talk about ethics very briefly, when you send a letter out, a lot of people call in, but then it's declining revenue. So total consideration paid is $500, not 20% of total revenue for 36 months, which is $550,000 if you look at the math here. Different deal structure. Sam, the solo practitioner, has $1 million in revenue. Same thing. Buyer agrees to pay an amount not to exceed $600,000 or 3x EBITDA, because his EBITDA is $200,000. And in our hypothetical, Sam's take home is $500, right? So of the $1 million, Sam takes home $500. That's his seller's discretionary earnings. But Sam, his replacement labor is $300,000. So really the profit is $200,000. So 3x 200,000 at a rate of 20%. Same deal, but we're just using a different metric. In this one, the total consideration is $550. So it's either 5 or 600,000. If you look at this slide, it's either 5 or 600,000, but it depends on how you structure the deal. You can look at EBITDA. You can look at seller's discretionary earnings. A lot of times we're just kind of mashing the two together to get the most appropriate valuation. Let's talk about ethics, the California Rules of Professional Conduct, and the Business and Professions Code. We're not going to talk about the Business and Professions Code, but there's some stuff in there. California Rules of Professional Conduct, Rule 1.17, says that if a person sells their practice, death is a little bit different. I didn't want to get too much into this. The clients receive written notice of the proposed sale, and they have the opportunity to retain other counsel or take possession of their file. So there's a 90-day window where you mail a letter out, and then there's 90 days. And after that 90-day period, the buyer can actually look at the client's file to figure out whatever. Fees cannot be increased solely because of the sale. The entire practice or entire practice area must be transferred, meaning you're exiting the practice of law, or if you have an office in San Francisco and an office in Los Angeles, you sell your San Francisco location. You can do that, a geographic location. Confidentiality must be protected during the due diligence review, and conflict checks must be completed before integration, not before the sale, not before the close, but before the integration. Trust account compliance must be verified and documented, and failure to comply with the ethical requirements can destroy a deal or can destroy deal value instantly or maybe no deal. Building enterprise value. What are some steps to build the value? And then we'll turn it over to questions. I think you should act like a buyer of your own firm. Would you buy your firm? Would you buy you? Would you invest capital with your current financial reporting systems? Would you trust your compliance file without additional verification? Would you feel confident in the leadership? Could you rely on your own documentation procedures to protect the client experience? The client experience, what an interesting concept. So that's the view of the client going through the engagement with your firm. Would revenue continue if you disappeared for 60 days? For some people, the answer is yeah, it would stop. For other people, they're going, no, I leave 60 days every year. That's better. Buyers evaluate future cash flow, not past effort. That is really key. It's not that you deserve it. It's what does your business, your law practice generate? And this requires honest self-evaluation. It's a starting point of enterprise value. I think a 5-year preparation plan makes sense. We're going to go through these. Year 1, clean financial records. Year 2 is stabilize your margins. Get rid of low profit practice areas. We used to do conservatorships. Unless you do a lot of them, you cannot do them profitable. You can't do 1 or 2. If you have 800, yeah. If you have 100, yeah. But you can't do 1 or 2. And if you practice in conservatorship law or have ever handled one, you know what I'm talking about. Develop leadership depth. Year 4, reduce owner dependency. And year 5, go to market with your documented infrastructure. Preparation compounds over time. So clean financial and and professionalize your financials. Hire a competent bookkeeper or controller. A controller compiles reports. A CFO is more strategy. Most people don't need a CFO, and most people can get away with a part-time controller, but they're compiling the reports. Move to monthly financial reporting. Absolutely monthly financial. I would recommend cash basis and accrual, so you know how you're doing into the future, and separate your personal expenses from the firm. You just got to do that. And even just tracking it helps. Reconcile your trust accounts and review margins quarterly and correct drift. So if you've got a low margin practice area or low margin matters, you got to think twice before you take those. Strengthen and protect your margin. Raise your fees if you're underpriced. You got to just ask around. If nobody complains about your fees, you're charging too little. If 20% of the people complain about your fees, you're charging too much. If 10 to 15% complain about your fees, you're about right. Eliminate low margin service. Improve efficiency before hiring more staff. Don't just hire more staff. Get them efficient. Get that margin up. Measure profit per matter, not just gross revenue. In our firm, we measure profit per matter. What am I talking about? If we do something on a flat fee basis and our hourly comes in less than the flat fee, that is considered profitable. If our hourly time exceeds the flat fee matter, that's not profitable. That's an example. You also need to include write-downs on that. Or discounts. Again, I'm not a fan of discounting. Building predictable earnings is very important. Develop leadership depth. You got to get people that you can delegate to. Step 4, diversity and stabilize revenue. Reduce reliance on any one revenue source. The more streams of revenue, more sources of revenue, the better. 2 consistent marketing channels. I would say not 1, but 2, whether it's professional referral networks, client referral program, digital presence, paid ads, whatever it is, community positioning, speaking engagements. Step 5 is build brand equity. Invest in consistent marketing messaging. Define clearly who you serve and what you solve. The flip side of that is who you don't serve. Narrowing your positioning increases your authority. Strengthening your digital presence, even more important, especially in the age of AI. And maybe that's something we could talk about at some point, AI. We're seeing a huge change literally in the last 30 days on AI. We get a lot of our clients from AI. People type in and they come to us and they say, oh, I came to you through Gemini. Protect your reputation as if it were a financial asset. Every idiot has a megaphone. Everyone can go on Yelp and everyone can give you a 1-star review on Google, right? Protecting your reputation is more important now than it ever has been. We're going to end with some buyers and 2 case studies very briefly. Private equity. I mentioned private equity. They're typically looking for firms of 10 million or more in revenue. They're not buying solo practitioners without systems. Platform firms are looking for new practices to acquire. So we've onboarded practices that have systems that are well structured and others that are hot messes. Scale requires documented processes and leadership bench strength. Again, we talked about that. The market is evolving, whether you want it to evolve, whether you're prepared or not, it's coming. Firm A generates $1.2 million in annual revenue, EBITDA of 200,000. The founder conducts every consult and personally reviews every document. Accounts receivable exceeds 120 days. Documented systems are minimal. Practice trades for a multiple of 1.5x EBITDA, or about $300,000. I don't even know if this firm has value. So EBITDA of 200,000, $1.2 million in revenue, trades for 300. Firm B generates less revenue, 900,000 in revenue with 200,000 in EBITDA. 2 associate attorneys handle everything. The owner is in Cabo or skiing or whatever. Documented intake and drafting systems, clear revenue pipeline, consistent. The practice trades for a multiple of 3.2x EBITDA or 640, even though it's less revenue. So Firm B trades for $340,000 more than Firm A. This is a much better firm. I would look at if I had to rank choice these, I would take Firm B first, even though it's a higher price. That brings us to the end. We'll open it up for questions. We have offices in Northern and Southern California, Pasadena and Westlake Village. We also have a YouTube page. And I would really encourage you to look at it. We have over 400 videos on our YouTube page. And now I will open it up for questions.
Thank you so much. That was so valuable. You can either put the questions in the chat box or we are recording, but if you don't mind being recorded, you can unmute yourself and pose a question. So feel free. All right, since I'm not seeing anything yet, I have a quick question.
Yeah.
I understand that the seller must kind of open their financial books prior. How much are you sharing when you go in to buy a firm? And what is required? Because how do they know who they are really selling to?
Oh yeah, I mean there can be mutual disclosure. I think I mean for example, in my case, I think we have a reputation. Typically, people come to me because they have, there's a reputation thing, and they're not really asking a whole lot from me. But if you don't have that, I think it's a fair question. If do you have the ability to perform? And that's really if you're a seller. If person A is willing to pay you more and person B is willing to pay you less, how reliable, right, is that? Are you going to get paid? I know some attorneys go out and they get an SBA loan. So they put 10% down and they write a check to the seller. That's one thing you can do. That's a way to guarantee payment. But I think track record's very important. And I know that that's something we really pay attention to closely, is to have a good reputation. And then also the people who have retired or exited the practice, they can, we can direct them to those people and they can say, yes, they did what they said they were going to do. But that's a really good question.
Okay, I'm not seeing any others, so let me ask another.
Great.
Since you have acquired other firms, can you share some more stories where once you've acquired it, you've seen it grow tremendously, or perhaps you felt you bought something that maybe you shouldn't have?
Yeah,
And
so they fall into three buckets, and it's about a third, a third, a third. One is I wish I never would have met that person. The other one is like, eh. And then the other one's like, oh my gosh, this has been great. So we have done 30 acquisitions. There are three that account for 75% of revenue over the last 20 years. Okay. And they all had attributes. They all came with staff. They all had very strong branding. One was a multi-generational practice. One was Steve Bazaire, who was Bazaire, and Bazaire. For those of you in estate planning world, you've probably seen those trusts. Very strong branding. And another one was in the San Francisco Bay Area. But I would say the ones that we like to see the most, we're typically paying a higher multiple of SDE and EBITDA because the reason we just don't want to pay less for something that's not quality. Does that make sense? Yeah.
and my last question, what is the time frame? What is the quickest you've been able to acquire, and what's the longest it's taken?
Yeah, the quickest is after somebody dies. It kind of is like it's a now thing. I would say the next is somebody becoming a judge. That was 48 hours. Which is crazy. But I would say it's actually not a bad idea. And we are talking to people all the time. Some of these people say, you know what? We're in 2026, not 2026. How about 2028? And I'm like, fine. I don't have a problem with that. We'll just kind of queue it up. And then it's actually better to have maybe a year or 6 months lead time. Certainly in the estate planning context, trust administration matter service cycle, how long it takes to do a trust administration is probably about a year, 9 months to a year. You want to kind of wind down your matters. Most people don't want to switch horses in the middle of a ride. They want to keep with their lawyer until the end. So what we find is people stop taking matters. They're winding up their matters. And certainly in the estate planning context, maybe long time people say, oh, before you retire, I want to come in and update my estate plan. And that's perfectly fine because that relationship is there.
Excellent. I think that brings us to the hour. Thank you so much. If you send me the presentation, then we'll be sure to get it out to the
Will do.
participants as well.
Thanks for having me.
We so appreciate it. Everyone have a good afternoon and a great weekend.
All right. Bye-bye.